the third case that we have in the docket, and then remember, after this case, we're going to take a 5-minute break for a panel change. But we will now hear REY Group, Inc. versus REY.
Good morning, Your Honors. May it please the Court, Kimberly Berman, on behalf of the appellant, REY Group, I'd like to reserve 5 minutes for rebuttal. Your Honors, this case is about an issue of non-delegable duty and the imposition of joint and several liability. This issue arose during a construction site accident where the general contractor was sued for negligence and sought to impute the liability to a subcontractor on 2 different theories of liability. This Court should reverse and remand for 2 reasons. First, assuming that the jury understood the jury instructions as they were given and read those jury instructions and reached the verdict that they reached, then the trial court erred in assuming that the jury ignored those instructions and imposed joint and several liability after the trial.
So you're assuming that the 43% attributed to the cabinetry company is solely related to a violation of 450.061?
Yes, based on the jury instructions that were provided and based on the testimony that was alleged, that's what you have.
Wasn't the jury instructed as the issue for you to decide, the next issue for you to decide is whether Bonifant Cabinetry and or its agents were negligent in failing to undertake a safety inspection and warn of the dangerous conditions of the premises prior to Mr. Roy's fall? So if they read that and followed that and they said, you know, you guys knew that there was a big door that opened up to 17 feet below and you didn't tell Mr. Roy, you share some of the burden. Why didn't they follow that?
Because the next instruction after that regarding the defense burden specifically instructed the jury that if they find that Mr. Bonifant employed a minor under the age of 18 on the construction site, then they must assess a portion of liability and find that there was legal cause, and that's exactly what they did.
You all got a great benefit from the trial judge to quite a broad interpretation of that statute here. So in other words, if I get this right, if Mr. Roy was 17 years and 364 days old, he was on the bottom floor and the roof caved down on him and he suffered the same injuries here, you guys would say, you share part of that responsibility, cabinetry company?
Well, that's not...
Is that right?
That's the argument that was made.
Is that right under your interpretation of the statute?
Our interpretation of the statute had to do with different angles of it.
I understand that, but it's
yes,
the
that is correct.
The statute.
Because under the statute and under the whole child labor laws and the policy and the procedures behind the child labor laws is to protect children under the 18.
Before we get to the child labor laws, I want to go back to what you were talking about in terms of jury instructions. The jury was instructed as to the general contractor's obligation to maintain the job site in a reasonably safe condition and were instructed that's non-delegable, correct?
Correct.
But isn't there also a duty to warn?
There is a duty to warn, right. Yes.
And that, so we don't know, and the jury wasn't instructed as to the duty to warn being non-delegable, were they?
No, that's why.
So we don't know whether, really what the basis of the jury's analysis and verdict was, do we?
Well, we can presume just looking at the instructions as they were given, but there's never.
That presumes, your presumption with that has to be that it had to be child labor laws because they were instructed that of this non-delegable duty. But the non-delegable duty only related to this keeping the work site in a safe condition. It did not address the duty to warn.
But the duty to warn goes in with that. The case law all says,
Yeah, all right, go ahead.
the case law all discusses the non-delegable duty in that it's to maintain a safe premises. So the failure to warn it was subsumed within that instruction, and that was why we also objected that instruction, that instruction was an improper preemptive charge. It should not have been given. It wasn't a necessary instruction that would needed to be. And we also requested a special verdict form in order to parse out the two different theories, so that way this would not happen.
Was there ever a verdict form requested that said what percentage of cabinet maker's fault is based on the child labor law?
There was not a requested verdict in
Without
writing.
that,
There was questions.
Without that, I mean, assume that it had parsed it out a little bit more. Without that, if it just said, was any part of it, the answer is yes. Well, how then do you apportion fault?
Well, that's why there could have been, if there was a question.
Could have been. No. Could have, this ain't coulda, shoulda, woulda. This is what was actually requested. And my understanding is, there was an oral request, which I think everybody knows that's not sufficient, but be that as it may, there was an oral request for saying, was part of it because violation of child labor law, but never was, tell me what percentage was, correct?
I believe the record, and there was two different portions of it, and there was another discussion of it where there was another angle to say, well, how are you going to determine the percentage? And that was an argument that was made to the trial court to be able to determine the percentage. So at first it was, did Mr. Bonifant violate child labor laws? If there was a question, then yes or no, then we would know from there whether or not their decision was based on that, because
So what?
our
But
position.
we wouldn't know what percentage. If you're trying to apportion liability based on your percentage of fault, and you're saying the percentage of fault was child labor law, how do you get there from here?
That's why they requested to try to have a jury instruction, to try to include that jury instruction that verdict form to comply, and the court refused to
The
give that.
instruction that's mentioned for the first time in the brief may have been a dandy instruction at trial, but nobody asked for it.
Well,
A verdict form and instruction, nobody asked for it at trial.
and more, I'll let you get that. And more importantly, is when it was being raised by, I guess, your trial counsel, the first question, if you find liability for, against Bonifant, is there any portion of liability based on the violation? Is there any portion of liability based on his failure to warn? I mean, that's asked, you're asking
Correct.
that to the trial judge. Opposing counsel objects, and then your counsel says, we're not saying to put a percentage, we're just saying, are they? That, to me, that answers this appeal, frankly. I mean, your own side says you don't need to put in the percentages. I think you absolutely need to put in the percentages for the exact reason that Judge Edwards is suggesting
I
to you.
guess we should let you answer that now.
Good luck with that. I mean, I know you didn't do it, but I mean, you get the hand that you're dealt, and that sometimes we're all been in the situation you're in.
Correct, and that's why the case law suggests that you put it in writing, you put the verdict form on play. I included two different examples of what the verdict form shouldn't have looked at, but correct, Your Honor, there is a question that was asked, and trial counsel did not focus on the percentages, so that's what we are faced with.
If you walked in and say, Judge, look, here's the issue here. How much of this fault's attributed to the child labor law? How much is attributed to failure to warn? And then break those percentages out. I think you're conceding that any part of the child labor law violation you are not jointly and severally liable for, but apparently you're conceding, and I think you have to concede as part of your argument, that as to the other part, you would be jointly and severally liable. In fact, that's what you're unhappy about. You're biting the bullet for 90%, right?
Right, and the fact that the question was asked in the way that it was and the court was rejected, it seemed to be that the court was rejecting the concept of strict liability, because we had argued to the trial judge that it was a strict liability offense, that you don't need to prove proximate cause, you don't need to do anything, so that's why trial counsel tried to put in a question to say, did Bonifant violate the statute? Because if he answered yes to that question, it didn't matter what the percentage was, because it would have been a finding of strict liability. We wouldn't have been at fault for his liability, even if he had this other percentage for...
What if they would have said 1% for the child labor and 42% for the failure to warn?
Then we would have been responsible for 42% and not the 1%.
And again, as, you know, beating Judge Edwards over a dead horse, I'm from Ocala, so horses and stuff like that. But, so, I mean, that's the problem. I mean, frankly, you know, your case is much better if your trial counsel didn't volunteer that, and in fact had said, and Judge, you need to put a percentage because we're not jointly and severally liable if it's child labor law violation, and that's why this is important, Judge, and that might have kicked into the judge and said, good point, let's do that.
And I think in the heat of the trial, after 10 days, you know, going through the trial, that was what the intention was from trial counsel, because when they put this defense to the jury, that was always the intent, to try to shift responsibility to another party that they wouldn't be responsible for. That's what FABRA is for.
Absolutely.
So they're entitled to do that. That was their defense. That was the whole way that they went ahead and did that.
Is violation of the child labor law, is that negligent, strict liability, criminal, what is it? I mean, it's a crime, apparently. It's a misdemeanor if you violate it.
Correct, it is a crime.
Which doesn't sound like negligence.
It's a crime if you violate it. It is also the case in Tampa, the Supreme Court, the court in Tampa shipbuilding case said that it was akin to strict liability. Again, they talked about it as far as Sloan, that it's either strict liability and negligence per se. So if it's strict liability, then if you're found at fault, then the other side, it takes away the opportunity to argue against that. If it's a negligence.
Is it an intentional tort to violate the law?
It's not an intentional tort to violate the law. There's nothing in the statute that talks about it. The point of the child labor laws is to protect children from being, or minors in certain ages, to be in dangerous occupations or out of school. You know, if you look at the whole statutory premise and the concept behind it, even kids under minors under the age of 18, they are prohibited from working during working hours. I mean, during school hours. This child, this minor had dropped out of school and was out on a construction site during working hours. So if you look at it, the whole scheme of the child labor laws and why it was put into place, it was to protect children for not being able to make decisions. They don't have the mature judgment, the discretion, the experience. Some of the exact occupations that are prohibited focus on.
When you look here directly for that, who does have the experience to walk out the door to a floorless balcony? I mean,
well, he was also.
I understand the broad scheme of things, but you get down to this case, it doesn't seem like it really matters if you're 16 or 26. If you're carrying boxes and open the door and there's no floor, something bad might happen.
But he should have never been there in the first place. You know, had he not been hired, he wouldn't have been hired. He wouldn't have been at the construction site that morning. He wouldn't have had this accident. Wouldn't have happened. We wouldn't have been here today. And
I'm sorry. Go ahead. Go ahead. Finish.
No. That was just my response to Judge.
How do you drive the 450.061(1)(e) says no minor 15 age or younger can work on any scaffolding, and then the statute that we're actually talking about, no minor under 18 years of age can work on any scaffolding, roof, superstructure, residential or non-residential building construction, or ladder above 6 feet. I mean, that seems inconsistent to me unless we're talking about 6 feet applies to any of those other matters in 2B. Now, that being said, I'm just throwing this out because you seem to be relying on a straight. The trial judge, I think, was the one that was kind of hitting it on the head, much to the chagrin, I guess, of both sides, because the guy was above 6 feet on the second floor. So by default, you kind of get the benefit of the statute, not how it was actually argued at trial. And nobody seemed to want to take the bait that the trial judge was scratching his head saying, well, you know, you can't be on an 88 floor high rise and say, well, you know, not a problem. I mean, I think that is a problem, but you know, still, it gets down to if they said, well, it's really a lot worse that you failed to warn as opposed to a 16-year-old kid walking out of a door that he wouldn't have any idea, 16 or 26, and okay, we'll attribute 1% to that. Well, let me follow up. I guess I'm rambling here. No, you didn't.
If it means anything, I agree with that.
Okay. Was there ever a motion for directed verdict, partial directed verdict, saying, you know, instructing the jury they had to find at least some liability on the part of Bonifant?
Yes, there was a motion for directed verdict as to the open and obvious defense as well as Bonifant's comparative negligence.
And to say, but I mean, it seems the instruction almost told the jury they had to find them responsible as a FABRE defendant as to at least the child labor law violation, but it wasn't checked. In other words, typically if that was raised and it was conceded, you as the judge you check and say, okay, we've answered that question for you on the verdict, now you just have to address the amount, right?
Right, because we didn't get an opportunity to amend the verdict form once that issue was erased at, the trial. And so there was.
Did you move for a directed verdict, not to say as a matter of law we win the whole case, but just that there has to be a finding jury that there is at least some liability on Bonifant's part, the Fabre defendant, for the child labor law, and the judge denied that motion?
It wasn't specific to the child labor law. It was comparative negligence on Bonifant's behalf. There was also a directed verdict on the plaintiff, because if you recall reading the transcript, the judge was thinking creatively that the argument for the child labor law violation was not to also put comparative negligence on Bonifant, but it was also to put it on the plaintiff for lying about his age. And if you look at the testimony that was presented and the after testimony from Bonifant, where the jury questioned asked to have questions after the fact. They asked if Bonifant asked for the age. They asked if it was against the law to lie about your age or for an employer to hire somebody. And so the jury was obviously attuned to this kind of evidence when they were thinking about the issues throughout the entire case, when they were listening to evidence, when they were hearing the jury instructions read to them, taking those jury instructions, which are the Bible to a jury when they go in to deliberate, and then making their decision on the verdict form. And so our position is, if you presume all of that, then you will get to the heart that the general contractor is not responsible for Bonifant's negligence in this case.
Just the interpretation of how do you read this statute and make sense of it?
Well, there's a couple things to actually make sense of it, Your Honor. The statute provides that no minor under 18 shall be employed to work on scaffolding, any scaffolding, a roof, a superstructure, residential or non-residential building construction, or a ladder above 6 feet. The only thing that says 6 feet.
Look at the provisions before that, though, as well.
Correct. The provision before, well, I think part of the argument was made that, 1F was inconsistent because that dealt with a minor under 15 working in heavy work on the building trades. But that doesn't necessarily mean it's on a construction site. A minor can work in a building trade outside lifting heavy lumber. There's no direct thing in this case, but there's other statutes. Pennsylvania has a statute that defines all these types of work. But
your interpretation of the statute would be that a minor can't work at either a residential or non-residential construction site?
Yes, according to this statute, because it doesn't, despite
That's honored in Shakespeare's words, more in the breach?
Say that again, Your Honor?
It's honored more in the breach. There are all kinds of minors working at construction sites.
But on different time periods. Minors are not permitted to work on construction sites during the school day. They're maybe on the weekend.
Or in the summer, let's say.
In the summer.
But this, under your interpretation of that statute, they can't be there at all.
That was the argument that was raised, and presented to the jury throughout the trial. There's certain things that they're prohibited. They can't be on scaffolding. They can't be on a roof. A superstructure is the second layer. So you have a substructure, which is the foundation, and anything below, and then you have a superstructure, so anything's above.
Your position is that a minor can't be at a residential or non-residential construction site at all, ever, period.
Doing certain things.
No, period.
In this circumstance, based on that was the argument that was made below, yes, Your Honor. But there's also some things that they can't do. They can't be on a scaffolding. They can't be on a ladder above 6 feet. They can't be doing, certain things in addition to that. Because
minor, shall be permitted or suffered to work in any of the following places. And that would be a residential or non-residential building construction.
Right, Your Honor. And that's what was instructed to, that was how the jury was instructed.
At no point in time can a minor be at a residential or non-residential construction site.
According to the interpretation that was espoused at trial, and according to the way and according to the way the trial court instructed the jury, and according to the testimony, that was what the argument that was made.
So
yes.
A 17-year-old can't be laying sod at a residential construction site?
Laying sod at he shouldn't be on, depending on what time of day, he shouldn't be on the residential construction site doing certain things.
Pick the best day that he can come out, whatever the best day and time. If I understand your espousement, I don't know if that's a word either today, if I'm making up words, but under your espousement of the statute, or you weren't trial counsel, right?
I was not trying to answer, Your
you're,
Honor.
I know you got the hand dealt to you.
I
get it.
did.
I appreciate that. You're hanging in there the best you can. Yeah, that seems to be hard to swallow, and
All right, you're into
But
your
we're not
rebut-
here,
All right, you're into your rebuttal, and again, I'll give you a little extra time since we've kept
we've been
you here.
rambling on the vaccine.
but if I can just
Go ahead.
respond to Judge Lambert, I would just say, Your Honor, that even if that is an issue that's coming up, that's not what we're here to decide, because the court allowed that
I get it.
argument to go forward. The
I
jury
get
was
it.
instructed,
You-
and
you-
they haven't raised a cross appeal. So we're
I get
not
it.
here on that issue
I get it.
today.
You won the espousement argument there. You won it. I get it.
Thank you, Your Honor. So we request reverse and remand to have the jury's apportionment, to have us liable only for the jury's apportionment.
Yeah, no, I just am raising that because I read the statute and I try to make sense of the totality of the statute, and I just can't do it. I can't, it doesn't make any sense.
We'll have to talk to the legislator.
So we'll talk to you
We'll ask
about it, too.
Eisnagel when we see him.
Thank you, Your Honor.
Did he write this?
Probably. It better not fall off of it either.
Good morning, Your Honors, and may it please the Court. My name is Andrew Greenlee. I'm here on behalf of Mr. Benjamin Roy. Your Honors, maybe I could shed a little bit of light on the statute because the way I read it, I think it makes sense. It is designed to prevent minors from working in inherently dangerous activities.
It's not what it says.
Excuse me?
It's not what it says. You know, you can be on a residential or non-residential building construction project and not, do anything that's dangerous.
Laying sod.
Well, ane sod's not in
that-
construction.
that-
don't-
that, I guess-
Maybe, but maybe not.
Then I agree with you. Then we're in agreement here. So just entering into a residential construction site doesn't have to mean, because in this, let's take this very case, for example, he was doing what's called a finish trade. He was installing cabinetry.
Which isn't inherently dangerous.
It's not inherently dangerous.
He's carrying boxes.
You're right. You're carrying boxes. You're bringing things up to the second floor of this building, which was about to be put on the market. So, but for this,
That's got nothing to do with it. You
Well,
know,
I do-
The state of, where it's at in terms of construction has got nothing to do with the interpretation of the statute. In fact, your interpretation or your counsel's interpretation at trial is absurd, that the 6 feet modifies scaffolding, roof, superstructure, residential or non-residential building construction. Apparently, the only thing then you could work on is Ken and Barbie's roof.
Your Honor, that's a traditional canon of statutory interpretation, where there is a clause that it equally modifies
I think
the
that makes
first.
any sense, so that you can work on a minor can work on a roof. The roof just has to be under 6 feet, which, again, I am
Right.
suggesting to you is Ken and Barbie.
Well, not necessarily.
What
You
other
can
roofs-
assemble a roof
What
while it's
other
on the
roof
ground.
under 6 feet is this person going to be allowed to work on?
Well, there can be. I could conceive of instances where it's a prefabricated roof that's being put together on the ground floor. And again, let's look at what the statute is meant to address: the inherent risk of falling from 6 feet. Right. So if there's my wife, we have a chicken coop. Okay, the roof is not 6 feet.
Sorry to hear that.
I'm part. So the point is that the evil that the statute, the substantive evil that the statute is meant to address, is putting children at risk of falling from a height greater than
So
6
they
feet.
can be at a residential or non-residential building construction site as long as it's under 6 feet.
Yes,
As long as they're on the ground floor.
as long and look, if the only way to square this provision with subsection F, where they say you can be no minor under 15 can work in the heavy building trades. The only way to make sense of that provision is to read it in my way. And don't just take my word for it. Ask DBPR.
No, we don't ask DPP.
We don't ask you
Well,
what they are.
the court is, Your Honors,
We don't even care who they are.
well,
The statute says what it says. And
But-
and we don't need, the building division to tell us how to interpret what the statute says.
That's right, and Chevron, aren't we going away from the Chevron doctrine? And isn't there some
Well,
constitutional amendment we just
Something like
had?
Article 5, Section 21 says the court may not, not should, not can, may not defer to agencies' interpretation of the statute or rule. Isn't that the current state of the law in Florida?
my understanding is under the Verizon case, which is cited in our brief,
Is that before Article 5, Section 21 was enacted due to popular demand and vote?
I haven't read a case where they interpret and square those provisions, but
I want to just check the timing, that's all I'm saying.
okay, Your Honor. And, well, in any event,
But your guy fell off higher than 6 foot. Isn't this what the statute says we're trying to prevent minors from being on construction site scenarios that, using your interpretation of this uniquely worded statute to prevent this kind of thing?
right, again.
So they're right. I mean, there should be liability.
I completely disagree, Your Honor, with respect. With respect, this was a finished trade. The building was about to be sold.
It doesn't
doesn't
have anything
matter.
to do with anything.
You really are going down the wrong rat hole here. You're trying to snatch defeat from the jaws of victory again.
Well, let me back up then and turn to the other point, which I think is the easy way to resolve
Tell you
this
what,
appeal.
let's stop. Let's go down. It's your time, so let's go down it. Show me in the statute where it distinguishes the state of completion of the project in terms of the ability of a minor to be there or not be there. Give me the section number that does that.
Your Honor, subsection F says no minor under the age of 15 can work in the heavy building trades. I think by negative inference, that means that minors who are above 16 and 17 and 18, or 16 and 17, minors who are 16 and 17 can work in the heavy building trades.
Except then you go to 450.061, 2B.
Right, so they can't be doing things that are inherently, and if I'm not mistaken, the statute, the name of it talks about, in the title of it, inherently dangerous activities. It's in the statute. So the statute
But how do you get where the guy's working not to be 6 feet up?
Well, look, you can imagine, and I just hypothetically.
No. It's either above 6 feet or it's not, and it's above 6 feet, right?
Okay.
Right? Yes? You'll give me that?
It is on the second floor, so technically it's
Okay,
Well,
so he was
17
working
feet.
on- he
You
was
can
working on
answer,
6
you can
feet.
answer directly, Judge Edwards' question. He was above 6 feet. Everybody who's here, everybody probably in the audience knows that. So that's a problem under the statute.
If he's working and you want to have 6 feet, you want 6 feet to modify everything in 2B, correct?
Yes.
Okay, so he's working residential or non-residential building construction above 6 feet. Yes or no?
He is on the second floor of the building.
And give me the 6 feet, will you?
He is suspended above 6 feet in the air,
He's at a
yes.
residential construction site above 6 feet, isn't he?
Yes, Your Honor.
Okay, and the statute says you can't have him do that, doesn't it?
Could I-
Just yes or no?
Yes, Your Honor, but if I might.
Okay, go ahead, yeah, of course. Go ahead.
If I might give you, could I provide you all with a hypothetical that was actually raised at trial to our expert witness that could maybe help clarify this difference? You can install cabinetry above 6 feet in an existing, you can do a remodel job of a kitchen. So you're technically installing cabinetry and you're above 6 feet, you're on the 60th floor of a high rise, right? There's no inherent risk of falling out of that high rise because the building is finished.
That's not what the statute says.
Well, the statute is meant to address, and this is our position, and I would like to move on to the two-issue rule because I think that we went under the two-issue rule, but our position, so I'm addressing the
Too
question.
much fun with this.
Your Honor, if I might, I don't seem to be making headway here. I do think.
Go ahead.
Your Honor, the easy way to dispose of this case is the two-issue rule, because this, in the words of defense counsel below, and this is a quote, "The court cannot discern whether the liability portion attributed to Bonenfant was based on a failure to warn or a violation of the child labor law statute." Not my words, their words at trial. We know from the two-issue rule that if there's a general verdict form and it's equally sustainable on one ground as it is on the other, then you can't show prejudice and you can't obtain reversible error. It's a straightforward case.
And I think it seems that should have been evident of our discussions with Ms. Berman. And she's done the best she can with a bad set of facts handed to her by not her. I'll just make it clear for you, if her trial counsel had actually came up with a verdict that said, I do want to have these things on the verdict form, and I do want to have the percentages apportioned to how much is child labor law and how much is duty, failure to warn. And you objected, and the trial court had sustained your objection and did not allow the verdict to read that way. We probably would have dispensed with OAs and reversed your case, okay? That, you can talk to the rest of these two fellows. That's how I see it. Now, that being said, she understands the hand that was dealt her. And that's the problem, as Judge Edwards and I and Judge Cohen have related, is the two-issue rule. We can't tell now because the last question was not asked on the verdict form. And in fact, trial counsel says you don't need to put it on there, which you should be hanging on to that like grim death.
Your Honor, I am. And,
Okay.
He's trying to.
You're trying
I'm
to.
trying
but you're
to,
sure-
and
You want to defend a statute that is poorly drafted, and however when it gets interpreted, your guy was, I get it, he wasn't trying to, build an atomic bomb on the second floor. I get it. But he was on the second floor, he fell off, and I get what happened. We all understand that. But there certainly is good logic to their argument that this statute should have some application, whether it's strict liability or not. It certainly has some application here. It's just it wasn't ferreted out here sufficiently for us to be able to say that we know all 43% is attributed to the child labor law violation because the instruction didn't tell the jury to do specifically that. So you should probably take what I'm saying here and go down your rabbit hole with the rest of them for the next 9 minutes. But, that seems to be the scenario here.
Your Honor, I couldn't have said it any better than you did, and
I think a lot of people could say it better than I did, but I was just winging it.
So you agree with him?
I agree with him wholeheartedly,
I thought you
and if, we would ask the court to affirm on any grounds that especially on those grounds, they're particularly
Possibly
strong. Yeah, but I do want to make one point, just to amplify one thing that you said. It wasn't just,
That needed amplification?
no, I think that actually he was.
I need a break
No,
now.
go ahead, amplify.
But they argued in closing arguments, there was a Bonifant failed to warn, he failed to inspect, he failed to train. There were all these different duties that he breached, and it's very susceptible, it's logical for the jury to award damages or attribute liability to Bonifant on those grounds. I would like to make one point here, because I think it's worth considering. For all the supposed unfairness about the application of the joint and several liability, it's not the end of the world for them. They can sue Bonifant for contribution. They can sue TEXWOOD.
We're aware of that.
And they have, Your Honor.
But winning a lawsuit is not really what they're after.
Well, maybe so. Maybe they want to make good law, but it's not as if there is a...
Just don't want to pay 90%.
Well, and again, I guess that's my point, is that if they sue Bonifant for contribution, or Bonifant Cabinetry, Inc. for contribution, and they sue TEXWOOD for indemnification, which, by the way, they have, those cases they're stayed in the lower court pending this appeal, then they're not going to be out the 90%. So the law of joint and several liability is actually operating as it should be, and there's no major injustice here in holding them jointly and severally liable here. The law is operating as it should. Let's not lose sight of the fact that this was a rather egregious instance of negligence. I mean, if you look at this is kind of, the podium sort of resembles the balcony. So there's an open swinging door, as is the custom on this job site. He goes and he kicks with his foot to go out and dump the boxes out, and he falls. There's no floor underneath him. He falls 17 feet onto his face.
They're not contesting any of that. They're not contesting the damages your fellow suffered. They're not arguing
Well,
any of that.
I just
We
think,
all get it. We all get it. Just because we ask hard questions about stuff that you're taking a position that probably was, whatever position you choose to take. I mean, I think we made it clear as to what our concern was vis-a-vis the appellant's case. But that being said, they have valid arguments. It's just they kind of,
and I don't
no pun intended, they didn't take the final step here.
It's actually not,
I don't
it's
mean
not
that,
that
I don't
funny.
mean that dismissively, but I mean, that is, it is the final step.
No,
but they
this is a
should-
tragic case, and don't think that we're not taking it.
No,
seriously.
it is it's a sad thing that happened to your fella, that, the injuries he had, the IQ loss that he had, and it certainly is a scary thing for anybody. We get all that, and taking the next step was simply, in the process, it was, they talk about a two-step process here. The third step is what needed to be taken here, and that inures to your benefit.
Right, and I
It's
also,
appeal purpose.
and I also, just for purposes of clarity here, there are other, in our view, other reasons why the child labor statute shouldn't apply, and that is because there's something a little bit strange about saying a minor shouldn't recover. You take a statute that was meant to shield the minor.
Did you cross appeal about the application of the child labor law?
We didn't cross appeal, and the reason why is because we won below. We were afforded complete relief, notwithstanding we won despite of the fact that they were allowed to inject an issue that we didn't
Well,
feel
if you
was.
convince us that the child labor law shouldn't apply, where does that get us here today?
If the child labor law doesn't apply,
Where does
well,
that-
then that means that they can't establish reversible error. That's their ultimate burden as the appellant.
But you argue a lot on your appeal, on your answer brief about things that you've not contested about the trial court's ruling by filing a cross appeal. And they correctly point out in their reply brief that you don't get to have your cake and eat it too. I mean, you have to address the issues that they raise as to why they think it should be reversed. You don't get to say, oh yeah, but the judge really screwed up things along the way too, but we still won. But let me get a chance to talk about it while I'm over there in Daytona.
I appreciate that, Your Honor, but at the end of the day, they're the appellant. So they are the ones who have the ultimate burden of showing there's reversible error. And if we show that there isn't a violation of the child labor law statute, then they can't carry their burden. So even if we didn't cross appeal, we can still talk about it. And I recognize, and I'm not going to take another run at it because I don't think I'm convincing anybody, but I do want to point out the perverseness of ruling in their favor. You would be preventing a minor who suffered a grievous injury because of their negligence. You would be preventing him from recovering what he fully is entitled to.
We deal with legal issues.
Right.
Okay, we don't deal with the emotions of the case. We're
Understood.
dealing, we're a court of correction of error, and that's what our responsibility is. And so the pulling at the heartstrings is not part of our analytical process.
Your Honor, it's not just me saying that it's unfair to do it. There's a federal court in a case that's cited in our brief, Tierney versus Black Brothers, and I believe the Florida Supreme Court has said it too. You have to be within the class of people who the statute is designed to protect in order to claim its benefit.
But again, you're trying to argue that the child labor law doesn't apply, and you didn't cross appeal that.
I mean, the judges ruled it did.
Right.
It
You
did.
not-
If you didn't like that
you don't
ruling,
like
it's your
that.
yeah, you have to cross appeal.
My understanding is that there was never actually a finding that he did violate the child labor law violation. The judge ruled against us on a motion in limine, and we ultimately prevailed. So if we were to file a cross appeal,
You're not
what's the
getting
document?
the child labor law was in play because you had jury instructions about it. So the judge didn't say there's no child labor law violation, so you defendant don't even get to talk about it. They did prevail on that discussion. You don't seem to like it. You're saying that it's not intended to do this. You lost that at trial court, right or wrong. It's not being cross appealed here. I get it. You won. I get it. But you're missing the point that we're trying to tell you about is you can't sit there and complain about what the trial judge did because you've not appealed it. It's part of what we have to deal with, that's part of the program here.
I understand, Your Honor.
Okay,
I guess my only point is that if you were to write an opinion reversing it, you would have to talk about the child labor law statute, and you would have to say it's applicable because X, Y, and Z, and that would upset the interpretation of DBPR. That would upset minors' work on job sites a lot. So I think that it would be disrupted.
No, we wouldn't write anything like that. We'd say this was the issue that was presented. The issue was not cross-appealed. This is what we were dealt with. Do we now reverse because the verdict suggests that 43% liability attributed to Bonifant actually is the child labor law matter that's not been cross-appealed, the applicability of that law?
Right.
And that's what we would write about. We wouldn't upset the child labor law scenario or scheme or plan or what have you.
Your Honor, it's my understanding, and maybe I am completely wrong, but I always thought that you didn't really appeal if you won the issue. Now, we won, and so I didn't think that there was any need to cross-appeal because, again, when you're filing
You didn't win on the non-applicability of the child labor law.
it was presented to the jury, Your Honor, I do agree with that. But typically, you attach an order to your notice of appeal. Here's the order that we're appealing from. Well, there is no order. There was no finding.
If you had a car wreck case and the judge gave a seatbelt defense instruction, and you won, they're appealing, but, you're worried it might go back for another trial. If you didn't like that seatbelt defense, you'd cross-appeal that and go, this shouldn't apply. Same thing here. If you didn't like the application of the child labor law, you should go, well, this case might go back for a retrial. I better cross-appeal that. But this is not a seminar. This is,
But fair enough, Your Honor, but be that as it may, again, they're the appellant. They have to establish reversible error. If they didn't establish that.
Counsel, we get all that. We know that they're the appellant. We get
Okay.
all that.
we're anxious to hear what they have
You're hearing
to
us,
say.
but then you're saying the same thing over that.
I'm trying to be responsive and trying to really defend our course of conduct, Your Honor, and I think it was reasonable, again, for the reasons that we stated. And, Your Honors, we would ask that the court affirm the ruling of the trial court. Thank you.
Thank you. And I'll give you some extra, I'll give you a couple minutes extra, so go ahead.
Okay, I understand your position, Your Honor. As far as what was just discussed.
The two-issue rule really is difficult.
It is, Your Honor, but I don't think in this circumstance that it applies. Because what you have is you have a defendant who is appealing the plaintiff obtaining a verdict. And therefore, you would be, in those situations, you would be looking at the two issues that were presented to the jury. If there was multiple issues under a negligence cause of action, you would be focusing on that. There was one cause of action. It was negligence. That's all we have here.
Doesn't the two-issue rule apply to defenses?
It does, but it's when the plaintiff brings an appeal. It's not when the defense brings an appeal based on it. It's when the plaintiff brings an appeal because there was a defense verdict and they are saying that there is no basis for the underlying defensive verdict because there was multiple issues and they're saying there's one issue that was wrong. So in this circumstance, the two-issue doesn't apply. As far as the written verdict form, we're all in agreement that it would have been best practice to provide a written verdict form with all that information to provide that. But the law is clear that as long as you provide that and put that on notice, put the court on notice, it could have corrected. They didn't bring the jury verdict back to the courtroom until the next day when it was given to the jury. So that if the judge would have allowed counsel to add additional lines, to add additional questions, that could have all been corrected before the jury was charged, before counsel finished their closing arguments, before close of evidence. Obviously, that would have happened beforehand. All of that could have been done, and the trial court rejected the argument on the strict application of strict liability, rejected the inclusion of being able to parse out these questions, and it would have been futile to.
But at the end of the day, if all the questions that your trial counsel had requested were put on the verdict and they were all answered yes, you would still be in no different position of us being able to tell what percentage of Bonifant's 4 to 3% is attributable to child labor violation and to the failure to warn. That's the end of the day, isn't it?
Well, at the end of the day, but I think, Your Honor, there was still, it would give trial counsel and our client much better peace knowing that they found Bonifant liable for a violation of child labor law, and therefore,
Your client might not get that piece.
What was that, Your Honor?
Your client might not get that piece in this appeal.
I understand that, Your Honor, and I understand my time is, almost up. I'm not going to continue to beat a dead horse. Thank you, Your Honor.
Tough panel, especially here. Good effort.